today we are going to discuss again very important topic. Uh, the chapter talk about process to compel production of a thing. Basically, it is search and seizure. Now, search and seizure play very significant role within the criminal justice system. It is an enormous power which is there with the law enforcement agencies, which they exercise when they do search and seizure. But at the same time, the every single search and seizure resulted in violation of privacy of a resident in whose premises search is being carried out, and accordingly there is a requirement to have some kinds of a balance between the right to privacy of any individual persons, at the same time the necessity for allowing the police officers and others to execute search. They can do the search. So, very important topic. In fact, if you ask me that what is the most significant change brought by the new criminal law, I will say it was on search and seizure. There is a requirement that when police do search and seizure, they have to do video recording, or law says it should be under surveillance of audio video electronic means under 105 of BNSS. So very powerful section, very important section. In fact, in my view, this is the best thing what we got under the BNSS in the new criminal law. So let me begin our class or discussion today on process to compel the production of things, search and seizure, use of electronic recordings under the BNSS. Now, when we talk about search and seizure, we will also look into police power to search. Now, the search can be with search warrant, without search warrant, when with search warrant, when without search warrant. What are the safeguards which the law has prescribed? Power to impound, confiscate or confiscation under the CRPC or special laws. Now that become BNSS. How to dispose of the things, etc. So all those things we are going to discuss in this today's class on search and seizure. So very important chapter, procedures within the criminal justice system. Now, when you want to look at the kinds of impact which the search and seizure has on the individual person's rights, this comment from the case is really worth mentioning. So, in State versus Bhagwan Singh, and the same comment has been referred to in many other judgments, court says an Indian citizen's house, it must always be remembered, is his castle, because next to his personal freedom comes the freedom of his house. Just as citizen cannot be deprived of his personal liberty except under the authority of the law, similarly, no officer of the state has a prerogative right to forcibly enter a citizen house except under the authority of the law. So, the search and seizure is always resulted into violating right to privacy, but then when you are depriving someone's right to privacy, etc., you require authority of the law. So, we always, police agency need to remember that when you enter someone's home, we are depriving their liberties, etc. So, what does search basically implies? Now, search is a very important tool in whose hand? Authority. It can be ED, it can be police, it can be income tax department, it can be central excise, any agencies, revenue officers. So it is an effective tool in the hands of the authority, and at the same time it constitutes a serious invasion on the liberty of a person. Liberty, privacy, particularly when the person's house are being searched. What does search means? Search means looking for, exploring, probing. So when we search, we look for something, we want to find something. Now, as a student of law, you all, including me, being the student of law, we all do research. What does research implies? To search something. Research, again you search something. Search implies you look for something, you are exploring something, you are probing something. Where search can be taken place? House, building, premises, person, vehicle, vessel. Remember the definition given in section 2 of the place, which include house, building, premises, vessels, etc. Why we do search? For what we do search? Search implies discovery of contraband article, illicit good, stolen property. So we do look at all those materials. Who look at for those materials? Police. Suppose any one of you from your residence, there was some thief enter. In the night, he committed theft of a jewelry, maybe worth 10 lakh rupees. Now, nobody knows where the jewelries are. Now, somehow police able to find the culprit or at least have a suspicion about the culprit. What's the way out to find that jewelry? Where the police will do search? Any probable place where that accused persons might have kept the jewelry. It can be his home, it can be relative home, it can be goldsmith where he might have sold it. The search can be carried out, and from search we can find those jewelry from there. So discovery of the contraband article, illicit good, stolen property, they can be searched. This is very important tool by which we can find all those material which has been taken away by some criminals or other persons. What else we can search? We can search for document. Many times might be some document, someone has written say dying declarations. We may try to find where the dying declaration note is. Someone might have done some transaction of which the bills are there. Police may look for those documents. So document which may be relevant or incriminatory in nature, so anything. Evidence of guilt of the persons against whom the cases are. So all these things can be searched by the authority who has power to do search. In front of us, who is the main authority who has the power to do search, are the police officer. Most of the time they do search, but there are other persons also. So search is, again, it's a very important thing. Now, when we do the search, remember this definition we have read in section, when we discuss about section 2, audio, video, electronic means. Now, in every single search and seizure, there is a mandatory requirement that the process of search and seizure need to be recorded by audio, video, electronic means. Now, when we look at this search, this section we have discussed while discussing about the arrest. And there, at that point of time, we discuss That suppose police want to arrest someone and suddenly that person has took shelter in someone else's home. What police can do? Now police can go there, police can search, police can try to find out the person who is hiding. So here the police is searching to find the person. That possible under the law. In the same way, they can do for goods, etc. When we discuss this section 44, when the power of arrest we are discussing, there we have also discussed that this section says that suppose if the police wanted to enter someone's home where the accused has took shelter, the family member or the homeowner need to give access to the police for entering the room. But suppose if they don't give access, section 44 says police can use all means necessary. That means they can use force. Law permitted. So even when they want to do search of a person's etc., the force can be used. While a person being arrested, with this also we have discussed 50 BNSS, 49 BNSS. When a person being arrested, the police do has a power to search that person's body. And if police found some incriminating materials, police found some weapon, etc. from that person, police can search, seize those materials, those offensive weapons, etc. So that's under 50. So one category of search could be when they do search, when they arrest, after arrest, they can do search of the persons, their body, and thereafter they can also, if they find some material from the persons, they can seize under 50. So 49 we have discussed already when we discussed about the arrest. 50 also we have discussed. Now in the new law it says immediately after the arrest. So once a person being arrested, the police has a power to search the body of the person and then seize any contraband article. If they found, they can seize them. That permissible. Place we have seen section 2s in the definition clause we have seen that the place includes house, building, tent, vehicle, vessel. The first word was include. When the first word is include implies that illustrative in nature, there might be other thing also. Now, when we talk about the search, remember, when search is carried out under section 44 and 50 and 49, it was without warrant, because the police can arrest without warrant. When they can arrest without warrant, they can search the persons also, they can seize the materials also. It can be with warrant for the arrest, etc. Same way, when we try to find some goods, etc., material or document or incriminating things, those search can also be conducted with warrant or without warrant. That possible under both the sections. So search can be with warrant. We have an entire chapter which is talking about search with warrant. What does that implies? A search warrant basically is a warrant. Warrant means direction. A search warrant is a warrant issued by a court for the search of a place to be executed in the same way as a warrant for arrest of the person, subject to the special safeguards provided in BNSS. So whatever the safeguard provided in BNSS, the persons can be searched. The direction has been given in the warrant. Simply speaking, it is an authority given by a competent public servant, normally judge, to search a place, but there can be other person. It can be executive magistrate also in many circumstances. Seizure, once the search is being carried out from that place, say any materials found. So suppose police has done search on person X, and in that person's X premises, police found a revolver. What they will do? They can seize. We have seen few weeks ago from a Delhi High Court judge home, bundles of monies are being burnt. Suddenly there was a fire, and the fire brigade came. It says ground floor, all the monies were there. So any accused person whose premises being searched, police found that these are all illegally obtained monies are there. What police can do? They can take possession. They can seize them. Possible under the law. So when a police do this kind of a search and seizure, they require do some kinds of planning, some preparation of witnesses, because there are legal obligations. Under the law, when we are going to do search, law is very clear that at the time of search, there is a requirement of that at least 2 witnesses should be there. Law uses the word local respectable witness. So there is a requirement of 2 local respectable witnesses. These are the search, 3 basic element of search. What are those basic elements of search? When police do search, we normally suggest to the police that they should do something sudden. If the information leak in advance, then the person is frustrated. Might be the accused will siphon the amount, siphon the documents, sift them from some other places. So it should be sudden. It should be surprise. It should be swift. It should have there some authenticity, secrecy, coordination, which require in the police agencies. Section 85 in the new act talk about attachment of the property of the persons absconding. We have seen yesterday when how to process to compel appearance of the persons. We had discussed under section 84 clause 4, persons can be declared proclaimed offender. So next section is talking about it. There only we have seen also yesterday, there can be attachment of the property person absconded. With the attachment of the property, there could be search for those property. That possible. 86 says these are new sections, identification and attachment of the property of the proclaimed person. So when this is done, many times there can be search also. Now we come to the chapter on search and seizure, which is there in the CRPC, and we start from section 94. So 94 onwards, you will find a large number of sections which are there on search and seizure. So section 94 says, before starting search and seizure, it laid down again the lenient process. Remember yesterday when we discussed about when we have to compel some persons to appearances, we have 4 processes. First process was summon. So most easiest process. Second process was warrant. Third process was proclamation. And along with that, or maybe 4th processes can be attachment. Here also, the chapter when you start with, suppose police requires some document or some investigating agency requires some document. It does not require to do a search. Suppose there might be a case where one of you, say Pratik, have some document in his possessions. What police can do? Now 94 says, it was 91 earlier, police can send them summon, Mr. Pratik, can you please bring this document? Now if Pratik is agreed to bring the document to the police station, give them, hand over them, there is no need of doing search, because search is coercive mechanisms. So 94 permit that, okay, these are the lenient processes even in the search, that if the things can be done, if the things can be brought by sending notice, etc., we can send notice under section 94 of the Act. So 94 says, summons to produce document or other thing. So when any court or any officer in charge of police station consider that production of any document, electronic communication, including communication device, which is likely to contain digital evidence or other things is necessary. Say in your Sudarnath Law College, suddenly among unions, two groups, students groups are fighting. Or less than union, there are two groups among the students, the groups are fighting. Someone of you was there and recording the entire episode, all this fighting, etc., where someone got injury. Police came to know from CCTV camera or something that you have recorded the videos of all those fight, and it is very important piece of evidence for the purpose of trial of the case, trial against the persons who committed wrong there. What police can do? Now, one way could be then police can search your place, seize your mobile phone, but that's very coercive. If they send someone to you and you are ready to take the mobile phone to the police station, is there any need for using coercive measures? Answer is no. So 94 make that possible, and these are new changes are there in the new law. They have used this word communication device likely to have contained digital evidence. This was not there in the old law. Old law was 91. So now the police can send the person's notice, please bring this document to the police station. If the person is agreeable, they can bring the document. There is no requirement of any other coercive mechanisms. Clause 2 says any persons required under these sections merely to produce a document or other things shall be deemed to have been complied with when the requisition, if he causes the document or things to be produced instead of attending personally. Suppose you are the COE of a multinational company. Police need one X document from your company. Police send notice to you under 94 BNSS. Now, they do not want your presence in the police station. They want only that document. And that's why clause 2 says it is good enough if as a being COE, they have given notice to you, you can send through your staff to the police that particular document that serve the purpose. Does not require your physical presence there. So that's what 94. 94 is, now the wordings of 94 is far wider than what the wordings of 91 was under the CRPC. So the police can or any authority can send you someone to asking for any document which is required for the purpose of investigation, inquiry or trial. They can send you notice in writing. So 94 that permit. Very important provisions and very frequently used. In fact, in most of the cases, police use this provision. Earlier, they used to send notice under 91, asking the persons to bring the documents, etc. Now they will do under section 94. 96 says, when search warrant may be issued. So if there is a chances that the 94, 95 will not help, then what to do? Then there can be search warrant. So court can issue search warrant or other authority like executive magistrate can issue search warrant. So 96 says, any court has reasons to believe that a person to whom a serve summon order under 94 or a requisition under subsection 1 of section 95 has been or might be addressed will not or would not produce the document or thing as required by such summons or requisition, or B, such document or thing is not known to the court to be in the possession of any person, or C, the court considered that the purpose of any inquiry, trial or other proceeding under the Sanhita will be served by a general search or inspection, court may issue search warrant. So when after sending someone it does not produce, or court think that after sending someone even the person will not produce, or in the interest of inquiry, investigation, there is a requirement for search, a general search can be served. Now here you will find, see the word general search is there. This will indicate that there can be some specific search. So there can be search warrant that you can search only X document, very specific search. There can be such warrant that you can search any document which are relating to this case, general warrant. There can be such warrant that you can only visit Mr. X residence. There can be such warrant that you can find Mr. X in any place. So there can be general warrant, there can be specific warrant. That warrant, search warrant may be issued by the court, and the persons to whom the search warrant being directed, they may search or inspect in accordance with that direction which is given in the search warrant. Very important power, that's the concept of search warrant. But all search are not done with search warrant. So that means there might be search with search warrant, there might be search without search warrant. Both possible. So in some cases with search warrant the search is being carried out, some cases search is being carried out without search warrant. Clause 2 says the court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only the search or inspection shall be extended, and the person charged with the execution of such warrant shall then search or inspect only the place or part so specified. This is not general search warrant, these are specific search warrant. So the search warrant say that only in X room can be in X building, only Y room can be searched. They can do search only that premises. But if say general warrant, any places can be searched. So depending on the kinds of direction which issued by the court. Clause 3 says, nothing contained in this section shall authorize any magistrate other than the district magistrate or chief judicial magistrate to grant a warrant of search for a document, parcel or other thing in custody of the postal department. Now, postal department, we have a complete different procedure because that's a within government department. So that some limitations are there. Now, when we look at this provision of the search warrant, there is a requirement that such magistrate, etc., has reasons to believe that someone will not serve. There is a need for general search warrant. Then they can issue search warrant. So what does this implies? So the word reasons to believe coupled with other words contemplate an objective determination based on intelligent care and deliberation involving judicial review as distinguished from a purely subjective consideration. These functions being judicial, it necessarily follows that the court has to apply judicial mind. That's the basic principles. In a judicial processes, court has to apply judicial mind. In the judicial processes, court has to give reasons. So some justifications required. That's the basic requirement of any of these processes. There is another case called V.S. Kuttan Pillai, and court says issue of such warrant being in the discretion of the magistrate, it would be reasonable to expect of the magistrate to give reasons which swayed his discretion in favor of granting the request. I said, being the judicial warrant, etc., there is a requirement of reason. They have to give reasons, a judicial determination. So a clear application of his mind by the learned magistrate must be discernible in the order of granting such warrant. So whatever the thing which persuaded court to issue such warrant, there is a requirement, some justification need to be given there. 97 is about the search of the place suspected to contain stolen property, forged document, etc. Now, law permit district magistrate, sub-divisional magistrate, they are executive magistrate or judicial magistrate first class. if they have information and after inquiry as think necessary, has reasons to believe that any place is used for the deposit or sale of a stolen property or for the deposit, sale or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in any place, he may by warrant authorize any police officer above the rank of a constable, they can do search, etc. They can authorize to enter with such assistance as may be required, to search the same, to take possession of any property, to convey such property or article before a magistrate, to take into custody and carry before a magistrate every person found in such place who appeared to have been privy to the deposit, sale and production of any such property. Remember in the Nyaya Sanhita or your IPC, purchaser of the stolen property, etc., are also accused. So the person who is found, etc., they are privy to this crime can be arrested. They are privy to these offences can be arrested. So very powerful section where they permit that stolen property, etc., can be how the police can do. The objectionable article to which this section applies are these. There is a list: counterfeit coin, metal made, forged document, false seal, obscene object, instrument of material used for the production of any of the article mentioned above. So you must have the case of Tilgi. He was printing Indian currency note, stamp paper. So the machine from where it is being printed, dies which was there, all can be seized under the law. Search can be carried out, and in the search the things can be seized. Earlier it was there 94 CRPC. In law it is 97 of the BNSS. There are many cases when we find on search and seizure. So there is a plethora of cases which are available. So there may be circumstances like the case like Dinesh Auto Finance by state of AP, Andhra Pradesh, where the all the hire purchase agreement, etc., if they do in those hire purchase agreement, if they are defaulter, many times they get some order from the court, mostly under the Arbitration Act, for even taking custody of those hire purchase goods, etc. There is maybe need for search. Seizure under section 94 of the vehicle which is sold on hire purchase basis, in respect of which civil dispute pending was disapproved. So sometime court disapprove it. Executive authority must apply his mind. So anyone who is issuing the order with such, it's a function is judicial in nature. They must apply their mind while issuing the order for such and seizure. 98 says, now this is not, these are completely, 2-3 sections are there, which completely different thing. 98 says power to declare certain publication forfeited and to issue such warrant for the same. You must have been heard the case of Taslima Nasreen written a book called Lodja. Government immediately ban it. When any publications are banned or forfeited, automatically a search warrant can be issued for searching them, to finding them. Those warrant can be issued. So, this 98 permit searching those materials. It defined what's newspaper, it's a defined book. Clause says no order pass or action taken under this section shall be called in question in any court, otherwise than in accordance with the provision of 99. Now here interestingly, the remedy is given in BNSS only. Earlier it was in CRPC, so 94, 95 was there. Now here 9900. 99, it's a 98 and 99. Under 99, remedy is provided that someone can challenge it. So in against the Taslima Nasreen book, there was challenge which was made, and then High Court set aside it. 100. Now there are also search and seizure is from different circumstances. So 100 says search for person wrongfully confined. If any person wrongfully confined, court can issue search warrant to search that person. See what the section says. I am reading it. If any district magistrate, sub-divisional magistrate, or magistrate of first class, that means this power is vested to both judicial authority and executive authority. District magistrate, sub-divisional magistrates are executive authority. Judicial magistrate first class are judicial authority. If they have reasons to believe that any person is confined under such circumstances, that the confinement amount to an offence, he may issue a search warrant, and the persons to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person if found shall be immediately taken before a magistrate, who shall make such order as in the circumstances of the case seems proper. So the issues can be made if any person is being wrongfully confined, etc. The search warrant can be issued and the persons can be searched. Now, the by and large, the practical use of these sections are: suppose someone's daughter elope with her boyfriend. Now, daughter is adult. That person went to the police that okay, there's a kidnapping, it's a kidnapping will not work. She become adult. Now, many times people approach under this section, earlier 97, now 100, asking for search warrant, and there are some occasion when this kinds of order being passed also. 101 says when those victim is restored, any victim who is abducted female is being rescued, they can be restored to the family member under 101. So these all happened. This one case is on the where elopement cases, these kind of cases started, where someone's a wife run away with some other persons. The husband goes to the court asking for search warrant if he came to know where the wife is and asking for warrant from the court. Child, sometimes the order is being passed, so the uh, child was with the mother. Suddenly, child went to his school, and from there, the father has kidnapped the child, taken away. Mother went to the court for asking for order. Sometimes father also reaches, sometimes court a law, sometimes does not quote a law. So this is the one case, Zahirul Hassan versus State of Uttar Pradesh, where court says, in my opinion, it is revolting to judicial conscience and modern sense of justice and fair play that a person who has lawful custody of the minor should be deprived of such a custody by crude method as has been adopted by the husband in the present case. Particularly when such a forcible removal by the husband has no sanction under the law. Removal of the child by using physical force from the custody of the mother is a prima facie a wrongful act, more so when the child is of a tender age of 1.5 years. This act on the part of the husband of placing the child beyond the reach of the mother in such circumstances, in my opinion, in itself amount to wrongful confinement. Under the circumstance, I hold that no substance in the second submission also that it was not that the case was not covered by the provisions of the 97 of CRPC. So father taken away the child from on the road somewhere from the school or some other place. Mother approached court issue such warrant so that find the girls and handing over to the mother. So this kind of family-based situations, normally this 99, 100, 98 is being used. There is another case called Praveen Singh versus Bihari Singh. Father filed application for married daughter. So the married daughter, she, so he filed complaint. The complaint further overstated that 18/12/1985, Rekha wrote a letter to the complainant that should be taken within such time. Otherwise, she would have been no other alternative but to commit suicide. She has also sent a telegram on 19/12/85. The complaint averted that the respondent to Rekha is wrongly confined by non-applicant number one and member of his family, and she is not allowed to do anything. Learned magistrate, after going through application which with affidavit made the complainant and the letter sent by the Rekha warrant issued to the police station. So court issue warrant under these sections. That possible. So 9900. This for this kind of a situation, many occasions these sections are used by the different people. J engineering work. Labor has completely blocked the manager or owner of the in the basically manager extra was there in the factories and they were not allowed them to come out. Now executive magistrate order for search warrant that possible to find them. So there are many cases. MP Sharma is the issue of constitutional issues, whether any kinds of a search by which we find material evidences from accused place, whether that amount to right against self-incriminations. Remember, it does not amount to right against self-incriminations. So right against self-incrimination Article 23, only those things comes which someone force you to disclose from your knowledge. If something comes otherwise than knowledge, some material is being found, some documents are being found, some contraband article is being found, it is not right against self-incrimination. So court has made very clear in MP Sharma case. Now, what is the requirement for search? We'll look at the provisions 103 in the new act. In the old law, it was 100, where it says that you require, police require, when the police go for a search, they require at least two respectable witnesses who should be there during this search. So, such requirement is independent witnesses were required to be search witnesses, but they refuse evidence of investigating officers and other witnesses remaining unshaken. Convictions can be based on such evidences. So independent witness did not found, but so what the police will do? Police has taken some other persons. That was challenged. The court said the evidence, if the evidence is found reliable, it can be used. Instead of UFI versus Jakaullah is a Supreme Court judgment. So when you look at the 103 of BNSS, you will find it says for every single search and seizure, there is a requirement of two respectable witnesses. What if two so-called respectable witnesses not find from locality? Can take from the other places. Can be police personnel can become witness. It can be NGO worker can become witnesses. So in this case, state of UP versus Jakaullah, the requirement to have independent witness to corroborate the evidence of the police is to be viewed from a realistic angle. Every citizen of India must be presumed to be independent person until it is proved that he was a dependent of the police or other for purpose whatsoever. So if he is not independent, if it is got from other places, different questions. Otherwise, everyone is an independent witness. Now, this entire chapter, they talk about general provisions are there with respect to search. And what are those general provisions? 102 says direction, etc. for search warrant. So, provisions of the section 32, 72, 74, 76, 80, 81 shall as far as may be apply to all search warrant issued under this 96, 97, 98, 100, which we have seen about the person. So, same process will apply. 103. The most important section when we look at search, because this section talk about the requirement, the safeguard, the obligations of the law enforcement agencies. So what are there in 103? Clause 1 says, whenever any place liable to search or inspection under this chapter is closed. Any persons residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant, and on production of the warrant, allow him free ingress thereto and afford all reasonable facilities for a search therein. So if the person has a search warrant when to enter someone home, that person has an obligation to allow the police to enter that premises for the purpose of search. Now, very interesting clause 2. What if even on the strength of that search warrant, access is not given? Then clause 2 says they refer to your section 44. That means the section which you have seen in arrest, use of force. They can break the door, they can break the window, and they can enter the premises. 103 clause 2 permit that the police can use all reasonable force to get access to that premises. Clause 3. Whenever any person in or about such place is reasonably suspected of concealing of his person any article for which search should be made, such person may be searched. So, if suppose someone has kept something hiding in their pocket, please can do search of that person. 4. Before making any search under this chapter, the officer or other persons about to make search call upon 2 or more independent and respectable inhabitants. Remember this word, 2 or more independent and respectable inhabitant. What if 2 or more independent, respectable inhabitant is not being found? It's not end there, of the locality. So the locality from where search is going to carried out. You all are very brave students. Suppose police comes to just next door flat for doing search, and they came to know you are all soon enough the college law students. So some of you, police came and say that Mr. Surojit, can you be a witness? Sujit will say, sorry sir, I have too much work, I have to take permission from father. Police come and say to Vandana, Miss Vandana, can you become a seizure witness? Sorry sir, I don't have that much time, I have to go to the court, please excuse me. That's the reality. So law says we require 2 local respectable witnesses. Suppose if the search is just next to your home, how many of you will agree to become witness of the police, to become witness of the seizure? I believe many will not. So what the police will do? Police have their own witness in their pocket. We call it pocket witness. So they may call one satta man, they who do satta business, that okay, can you send 2 witnesses? I am doing to do search, and they will oblige the police and they will make witnesses. These are the practical challenges which the system faces. Many a time we don't want to be party to our criminal justice system. So law require that you require 2 local respectable witnesses. In many special laws, in addition to this, there is a requirement of say female presence. So for under the ITPA, Immoral Trafficking Prevention Act, we require at least 1 witness should be female. So there can be some requirement. These are the essential requirement. Then was the other requirement, clause 5, in whose presence search should be made. It should be made in the presence of the person who is the owner of that premises. And then a list need to be prepared of all the items found. They will prepare the list. It's not enough. They have to sign this list. The witness will sign that list. and a copy of the list need to be handed over to the homeowner, the place where the search is being carried out. So very powerful provisions. This is a requirement when they do search. You require two witnesses. The witness will sign all the seizure list. The seizure list signed by the witnesses, other persons, police officers, and a copy of the seizure list need to be handed over to the concerned person. The occupant of the place search or other person in his behalf shall in every instance be permitted to attend. So you have to allow the owner to be present. List etc. prepared, a copy thereof shall be delivered to such person. Clause 8. So you need to give copy to them. Clause 7, sorry, last part. Clause 8. Any person who without reasonable cause refuse or neglect to attend. So suppose they came to you that can you become witness? And you say, no, sorry, sir, I will not. If the police want, this is itself an offense under Nyaya Sanhita section 222. Refusal to accept the command or direction of the police officers, etc. So very powerful section. And then there's a coercive means in the Nyaya Sanhita that they can use as a coercive means if you refuse. But facts remain, in many cases, people do refuse to attend the search warrant, and this is the reality. This is the reality, nothing else. So it's a reality is there. Now we come to 103 is done. Now come to 104. 104 is disposal of things found in search beyond jurisdiction. So if the police is search outside the local limit beyond jurisdictions, how to deal with those things which is being found? So something which you can carry, something which can't be carried, something which are perishable. So there are different ways to deal with them when you see something. So when in the execution of a search warrant at any place beyond the local jurisdiction of the court, which issued the same, any of the thing for which search is made or found, such thing together with the list of the same prepared under the provisions hereinafter contained shall be immediately taken before the court issuing the warrant, unless such place is nearer to the magistrate having jurisdictions therein than to the such court. In such which case the list and the things shall be immediately taken before such magistrate, and unless there is a good cause to contrary, such magistrate shall make an order in respect of those goods, what to do. They can authorize where to keep them, etc. So that's the disposal of the property when they do. Now we come the general provisions D part, and the D part section is 105. I said in the beginning, the new BNSS, the most progressive and most important section, if it anything is included, for the purpose of ensuring rights of the citizen, it is 105. 105 says, recording of search and seizure through audio, video, electronic means. And law mandate the point when search will begin till the point when the search is end. This entire process of search and seizure need to be covered by audio, video, electronic means. Very challenging. And many police officer is facing lots of challenges in executing this provision 105 because they have to do video recording. Audio, video, electronic means in all places. But when we look at from the citizen point of view, I think this is best provision in the BNSS. Okay, what was happening earlier, or at least the allegation used to be raised on many circumstances. When you look at any trial, when the cross-examination of police being done, one question is invariably asked that, okay, you might have planted it. So there is always chance, and sometimes it do happen. You might have seen from some cinema or something. Maybe police comes to your place where you live in the ground floor. Police went from back gate and from backside from your window, throw say something in your room, contraband article, or they make sure that someone else will throw in something, and then from front door they enter to search and seizure and they found there. Possible. Now, when we do search and seizure from beginning and other point, end point, we can do conducted under the audio video means, so surveillance systems are there. These chances of planting of evidences become minimal. It decrease. Now we don't have that much chances of planting of evidences when the search is being carried out. In that sense, it is excellent provisions from the citizen point of view, because all those apprehension that police has planted or they have not went to do search and seizure, or what happened many times, say police went to scene of crime, they seize, brought everything to police station and prepare the seizure list, etc. Then they to call 2% and they signed the witnesses. Now those days gone. They have to do everything at the place where their search and seizure being carried out. So it may created some difficulty. It has created some difficulty for law enforcement agencies, but it really creating a foolproof systems where you have evidences, videos, recordings are being carried out, etc. So at least give some sanctity. The manner in which is being conducted, and even accused knows that entire process are videographed. Then the chances of saying in the trial that no, it is not me, we have not done, etc., those become immaterial. So 105, very important section. 106, it was earlier 102. Now this was the only section in the CRPC which permit about the seizure of the property of the criminal which they obtained by committing those crimes. Very powerful section. So 106, it was a replica of 102, and it says any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offence. Such police officer, if subordinate to the officer in charge of police station, shall forthwith report the seizure to that officer. That's 106 of the Act. So the search and seizure can be done. Property can be seized. We find that the definition of property is being included, and in the new property definition, property includes both tangible and intangible property. Clause 3 says every police officer acting under subsection 1 shall forthwith report the seizure of the to the magistrate having jurisdictions, and where the property seized is such that it cannot be conveniently transported to the court, or where there is a difficulty in securing proper accommodation, then it will be handed over to someone's custody, etc. Something which are perishable, etc., can be disposed of also. So the property can be seized. Earlier 102, now that become 106 in the new Act. They're the only six. Suppose someone did bribery. Now in West Bengal, we know the ministers are in jail, and from someone's residence, bundle and bundle of cash are being found from almost every places in Delhi. These all properties are, monies are illegally obtained money. From where the get power? Which section? This was the section 102. Now it is 106. Now here, interestingly, it can be tangible property, it can be intangible property. Law permit those property can be seized under 106. So there is a very interesting case happened. The case name is State of Maharashtra versus Tapas Din Yogi. So Tapas Din Yogi, was an engineer at Daman and Diu, change the plan. Like for example, we have Newton area. So some area is earmarked as commercial, domestic, institutional. So it changed some area and accordingly it manipulated price of the area. And through that, he got huge bribe. His family were living in Calcutta. And so money was kept in that the bank account and locker of his mother's name, the Tapasri Nyogi's mother's name. So what the police did, police seized the bank account in Calcutta. He very interestingly, he argued in the Supreme Court that 102 of the CRPC, which now become 106, is talk about property. When we say property, property means tangible property. So his argument was the bank account is a number, numerical number. It is not property. Locker is the place where you keep something. Locker cannot be property. That's his argument. Supreme Court negated this argument and they says that bank account locker are property within the meaning of the then 102 CRPC, and accordingly police has power under 102 to search and seize those property under that section. So this Tapasdi Nyogi case of the Supreme Court settled the view that the bank account can also be property. Before that, there is some High Court has said different comment there. So very interesting case. Now in the new Criminal Act, BNSS, we got one section, very powerful section. So I said about 105 is the best provision. 107, most dangerous provision. It was not there earlier. So new law, BNSS 107, most dangerous provision. So please look at this provision. 107 permit attachment, forfeiture or restoration of property. What kind of property? Property which obtained by doing some illegal thing directly or indirectly. Now, you see the language is so broad. Clause 1 says, where a police officer making an investigation has reasons to believe that any property is derived or obtained, comma, directly or indirectly, comma, that means the property can obtain directly. So you took bribe directly. You took something else. You did not took bribe directly, but you say, give me this 1 lakh share of that company. Indirectly you. As a result of criminal activity or from commission of any offense, he may, with the approval of the SP or commissioner, make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for the trial or try the case for the attachment of such property. Now here, by using the word directly or indirectly, and second, by using the word any offense, you see the word is any offense, the provision ambit become very broad. To give you example, what the apprehension is. Say, suppose in your locality, we are all live in Calcutta and we know there's a many people who do say illegal constructions. Let me give you example of illegal construction. Some illegal construction is illegal construction, illegal business. Someone doing this illegal construction from last 20 years and now become, say, 50 crores of properties owner. A case started 2 days against him for illegal construction and or mafia doing the capturing of property. Now all 50 crore asset which has been prepared, made by him, any offense by illegal activities, what the police can do, police can ask the court to attach the property. What court will do? Court will so cause him giving 14 days notice. That person must explain why the property will not be attached. If that person cannot give any justification of the property accumulation of asset, then court might think it's an attachment for property obtained by the illegal activities. The court can pass the order for attachment. Law also says that once the property is attached, the DM will sell that properties and the money proceed will be distributed among different victims. If the victim is not there, it will go to government exchequer. Say suppose someone is doing some business of asatta or drug or extra, what be might be. There are many illegal things. Nowadays, when we say any offense, the word offense is so broad that there are many offenses which are civil in nature, but they become criminal. So someone has not paid GST. There's a businessman, suppose in Calcutta. We know a large number of businessmen don't pay tax appropriately. We salaried class, we have no other option, but we have to pay tax as per the salary. But those businessmen, they never pay tax as per those processes. So some businessman might obtain and make the property of 100 crores in Calcutta. GST make a raid and they found that there is some manipulation and GST is not being paid. Offense. GST officers think or police thinks when the FIR is registered that this all 100 crore property is being obtained by defaulting or not paying the GST amount by doing this offense. Possible? They can file an application to the magistrate for attachment of all property. The court can pass order for attachment of the property if satisfied that all the property obtained by illegal activities. And if there is no victim, it can go to state exchequer. If there is a victim, it can be distributed. So this provision might be useful when we have a cases like Saroda, cheat fund. Money can be distributed among victims. But otherwise, my apprehension is more than this provision, more than use of these provisions, it will be used for the purpose of extortion. What is extortion? This is what I say is a legal extortion. So if a Thana OC knows that in his locality one builder are there or businessmen are there who has unaccounted money, he will be always on the radar of that OC. Okay, pay me this much money, but otherwise I will start 107 proceedings. So it will become an instrument for extorting money this way. Very powerful section. Now, this kind of power was earlier. Earlier, there was a power for ED, etc. So the kinds of power we exercise in very special laws. Now it becomes general provision under 107. Because the provision is very wide, there is a chances of misuse and very risky. But then that's what the provision is. So if the victims are there, the money can be distributed among the victims. So cases like Sharoda, cases like cheat fund, in all those cases, the amount can be distributed among the victims. But in other cases, when there is no victims, the amount can go to state exchequer. 108 says magistrate may direct search in his place, is earlier also 103, the same thing. So when a search can be given search warrant, the magistrate can also direct that, okay, you do search in my presence. Till 108, what we are looking at, these are all with search warrant. Now we have two sections, 185 and 186. In the old CRPC, it was 165 and 166. These two sections is talking about when search can be conducted by police without warrant. So does not require warrant. So police does not require warrant at all circumstances. Police can require warrant. If they get warrant, they can give. But in many cases, they don't require warrant of arrest and they can do search even without warrant. So from where they've got power? The power given in these two sections, 185, 186. When 185? 185 applicable in a circumstances when warrant is carried out within the local jurisdiction of the police officer. When warrant is carried out outside the local jurisdiction, 186 is applicable. So both the sections are there. Let's have a look of section 185. Any officer in charge, when they think that some materials can be found in some place, with the case which are investigating, they can do search without warrant. So the cases which they are investigating, in those cases, they have a power to do search. So the cases which they investigate cognizable offenses. Same officers can also authorize to subordinate also. The proviso has been added keeping in mind 105, which I said video recording thing. So it says those all such conducted under these sections, it should be recorded by audio, video, electronic means. If he is unable to conduct search himself, he can appoint someone subordinate to do search. The provision of 103, we have read 103, where it says we require 2 witnesses, local, respectable. We have to allow the owner to be in the premises presence. In his presence, search can be conducted. The seizure list need to be prepared. Seizure list need to be signed. The seizure list need to be handed over to the owner. So all these were 103. Clause 4 says all those safeguards are also applicable in cases when search is carried out without warrant. And clause 5 says, remember this audio, video, electronic means. It says within 48 hours, this audio, video, electronic means these materials need to be sent to the magistrate. So this is basically a check, dot recording to the court, along with all these seizure list, etc. 186. 186 is when police need to search outside the local jurisdiction, in other jurisdictions. So 186 says an officer in charge of a police station or a police officer not being below the rank of sub-inspector making an investigation may require an officer in charge of another police station, whether in the same or the different district, to cause a search to be made in any place, in any case in which the former officer might cause search to be made within the limit of own station. So Calcutta police want to do a search in Delhi. What they will do? They will go to the local police station of OC there and ask them to do search. And they will do search as if they are doing search under that provision. 185 will be applicable in those cases also. Might be some circumstances when the police does not have time to go to their local police. So police think that if they inform the local police, there might be such delay where the evidence may be destroyed, disappear, the person will run away, or things may not be found. Then law permit, then they can do search, and thereafter they inform the local police. That also law permit here. So clause 3 says, wherever there is a reasons to believe that the delay occasioned by requiring an officer in charge of another police station cause a search to be made under subsection 1 might result in evidence of the commission of an offence being concealed or destroyed, then it shall be lawful for this Calcutta police to do search in Delhi. And thereafter, they have to inform those police officers. Any police officer conducting a search under subsection 3 shall forward send notice of search to the officer in charge of the police station within the limit of which such place is situated, and shall also send with such notice a copy of the list, etc. So then, after doing search, you have to inform that police. The owner of the place search shall on application be furnished free of cost a copy of the record, etc. That need to be given them. Now, in search in USA, there is a principle called fruits of the poisonous tree. So under the USA Constitution, it is prohibited to do illegal search. So under their system, if a tree is poisonous, fruit is also poisonous. So any evidence obtained by illegal search and seizure is not admissible in USA. In India, we believe the tree might be poisonous. Fruits are fruits, so we can use them. So under Indian system, even evidence obtained by illegal search and seizure are admissible. It's not completely prohibited. So the Evidence Act or the CRPC for that matter, any law in India does not exclude relevant evidence on the ground that it was obtained under an illegal search and seizure. There are ample cases. This is one example, Satish M.T. Joy Immaculate, 2004 Supreme Court judgment. So what will happen with the irregularity in search? It does not violate seizure of the article. It cannot violate vitiate trial or conviction unless accused has been prejudiced. You will find under section 506. However, if the search is illegal, it creates some suspicions. So court will scrutiny. Court will try to find out really it's reliable or not. So it may affect the weightage, it may affect the value of that evidence. But per se, we can't say it's inadmissible. Court may, some evidence value may be decreasing. But there are cases where anything obtained by illegal search and seizures has completely ousted, and there is a reason for it. For example, state of Punjab versus Balbir Singh. Now, NDPS cases are such where convictions or non-conviction is completely dependent upon search and seizure. Don't require anything else. So someone's pocket, some contraband article is being found. Only search and seizure on which the entire case is. Now, in those cases, when search and seizure is not followed law, if it is not in compliance with the law, then court can acquit. And there are many examples like this where the Supreme Court has affirmed the acquittal on the ground that the search and seizure was not carried out properly in accordance with law. And search and seizure, if the search and seizure are illegal, there might be cases where persons may be given acquittals. Now, what to do when a property is seized? So, 503 talk about the procedure by police upon seizure of the property. So, it's in the old law, A 503 says, whenever the seizure of the property by any police officer is reported to a magistrate under the provision of this Sanhita, and such property is not produced before the criminal court during an inquiry or trial, the magistrate may make such order as he think fit in respecting of the disposal of such property or the delivery of such property to the persons entitled to the possession thereof, or if such persons cannot be ascertained respecting the custody and production of such property, etc. They can lay down the process in which they do. If the person so entitled is known, the magistrate may order the property to be delivered to him, etc. Power to sell perishable property. Suppose those properties are perishable goods. It can be destroyed. Some perish, then value become diminishes. Now, in those cases, it says the property can be sold, and that is permissible under 505. That when there is a perishable good, those property can be sold under 505. That's it on search and seizure.